There's a question burning in the minds of millions of people watching this case unfold, and today we are going to answer it directly. Can Mazi Nnamdi Kanu get bail while his appeal is still being heard? And more specifically, is a lawyer Ejimakor preparing to file for bail pending appeal inside this current 45-day brief window? We are going to walk you through the law, the precedents, the practical obstacles, and the strategic calculation behind this question. Because this is not a simple yes or no. It is one of the most consequential legal decisions Kanu's team will make in the months ahead. And if you leave this video without understanding what bail pending appeal actually means in Nigerian law and how it applies to Kanu's situation, you will be reading the headlines without reading the story underneath them. Stay with us. Everything is about to become very clear first. Let us establish what we are working with. As Ejimakor confirmed earlier this month, Kanu's notice and grounds of appeal were filed in February 2026, formally initiating the appellate process. The record of appeal, comprising the charge sheet, court proceedings, exhibits, rulings, judgment and sentence, has already been compiled by the Registrar of the Federal High Court in Abuja and transmitted to the Court of Appeal. What this means practically is that the clock is now running. Kanu's legal team is expected to file its brief of argument within 45 days of receiving that record, after which the prosecution responds within 30 days. That 45-day window is not just a deadline for the main written arguments. It is also the window within which any interim application, including a bail application, can be introduced into the proceedings. And this is where the critical question emerges now. What exactly is bail pending appeal? In Nigerian law, bail pending appeal is a specific legal remedy available to a convicted person who has filed an appeal challenging that conviction. It is not automatic. It is not a right. It is a discretionary grant, meaning the court must be persuaded to give it. And the burden of persuasion in a terrorism conviction sits very high. Under Nigerian appellate practice, the court will typically examine three questions when considering bail pending appeal. First, is the appeal not frivolous? That is, does the appeal raise serious, arguable grounds that genuinely challenge the soundness of the conviction, grounds that are not invented simply to delay execution of the sentence? Second, are there exceptional circumstances that make continued incarceration particularly harsh or unjust while the appeal is being determined? Third, will the applicant likely abscond or otherwise defeat the justice process if released? Let us apply each of those to Kanu's situation. On the first question, the answer based on publicly available filings is unambiguously yes. The appeal alleges multiple violations of Section 36 of the Constitution, including the court's failure to rule on a pending preliminary objection, leaving a bail application unresolved, and delivering judgment without allowing the defense to file a final written address. Kanu further argued that the trial court convicted him under a law that had already been repealed, the Terrorism Prevention Amendment Act of 2013, which was replaced before judgment by the Terrorism Prevention and Prohibition Act of 2022. He also argued double jeopardy under Section 36(9) of the 1999 Constitution. These are not weak grounds. They are constitutional in nature. They go to the heart of whether the trial was valid at all. On the second question, exceptional circumstances, Kanu's team has a compelling argument. The circumstances of his arrival in Nigeria were not ordinary. He was not arrested at a border post or in his home. He was brought from a sovereign country through a process that a Kenyan court has since declared unlawful. He spent over 2 years in solitary detention before conviction. The sentence handed down life imprisonment was imposed, according to his own appeal documents, without allocutus, without allowing him to address the court on mitigation before the heaviest sentence in the Nigerian penal calendar was placed upon him. Each of these facts, individually, is an exceptional circumstance. Together, they form a case that a bail application could present to the court with genuine seriousness. On the third question, the risk of flight, this is where the prosecution will fight hardest. The government will argue that Kanu has, by his own history, demonstrated a willingness to leave jurisdiction and remain abroad for years. His exit from Nigeria in 2017 following Operation Python Dance, which his team argues was forced, is the central fact the government will deploy against any bail application. This is the obstacle Ejimakor will need to address head-on, with conditions of bail that make any risk of flight practically impossible. Now let us address the most important sub-question. Will Ejimakor actually file for bail inside this 45-day window? Here is what Ejimakor himself has already said publicly. He explicitly confirmed that interim applications can be brought at any time, and he named bail pending appeal as one of the specific examples. He did not say it will not happen. He said it can happen. That is a precise legal statement, not an accidental one. Ejimakor is a careful communicator. When he lists bail pending appeal as a live option in a public statement, he is telling the world something about where the legal strategy is headed without committing to a timeline that the prosecution could prepare for. There is also a strategic reason for the timing calculation here. Filing a bail application too early, before the brief of argument is ready, risks appearing opportunistic and weak in the eyes of the court. Filing it alongside or immediately after the substantive brief, when the strength of the 22 grounds of appeal is fully on the record, sends a very different message to the bench. It says, we are confident in our arguments, confident enough to stake Kanu's liberty on them. That is a stronger posture, and Ejimakor knows it. But let us not pretend there are no obstacles. There are two major ones. The first is the nature of the charges. Terrorism convictions in Nigeria carry an unusually heavy presumption against bail at every stage. The courts have consistently treated terrorism cases as categorically different from other criminal matters, including other violent crimes. Any bail application in this case will face a court that has to balance its own constitutional obligations on fair hearing against the institutional pressure of the terrorism classification. That is not a comfortable position for any bench. The second obstacle is political rather than legal. Kanu's continued incarceration is not purely a judicial matter. It has been acknowledged by senior figures in and around the Nigerian government that his release, or even his provisional freedom pending appeal, is tied to political negotiations at the highest levels. There are forces that benefit from keeping him inside, and there are forces that want him out as a gesture of reconciliation with the Southeast. The outcome of a bail application may ultimately depend not only on what the court decides, but on what signals have traveled through political corridors before the ruling is delivered. Here is the bottom line. The law gives Kanu the right to file for bail pending appeal. The grounds of his appeal, as publicly filed, are strong enough to clear the threshold of arguability. The exceptional circumstances are documented and credible. The only serious obstacle is the terrorism classification and the political dimension that sits behind it. Whether Ejimakor files within the 45-day brief window or introduces it shortly after is a tactical question, not a question of legal possibility. What we can say with confidence is this: bail pending appeal is on the table. It has not been taken off. And for a man serving a life sentence in Sokoto, it is the difference between engaging his own defense from a cell and engaging it as a free man. Watch this space closely in the coming weeks.